Hello and welcome to the Brinks, Gilson & Leon Post-Grant Patent Practice Group webinar. Before we begin, we would like to go over a few logistical items. This seminar is accredited for 1 hour of Illinois MCLE credit. Please inquire if you wish to seek CLE accreditation in additional states. During the webinar, we will be providing 3 CLE codes. Please write these down. We will be mailing evaluation forms at the end of the webinar, and we'll ask for the codes. If you have any WebEx technical questions, please submit them in the Q&A panel on the lower right-hand side of your screen. We will also be holding a Q&A session at the conclusion of today's presentation. Please remember to keep the Send to default as all panelists. As an attendee, you are part of a larger audience. However, to maintain privacy, the number and names of attendees will not be displayed. All attendees will be in a listen-only mode throughout the presentation, and as a reminder, today's call is being recorded. With that, we invite you to sit back, relax, and enjoy today's presentation. I would now like to introduce your first presenter for today, John Beaupre. John, you now have the floor.
Thank you very much. This is John Beaupre. I am a shareholder in the Ann Arbor office of Brinks, Gilson & Leon, and it's great to be speaking today along with the other presenters, Kelly Burris and Rickard DeMille. So I will be talking about PTAB statistics. And in these first numbers, if you can see slide number 3, the first one that I've called up right now, this is an overview of AIA filings. And as I'm sure everyone knows, these numbers have been widely circulated, so I don't want to spend too much time on them. But about 2,000 PTAB filings have been filed in the 2 years since the AIA took effect. And most of those are IPRs and CBMs, the covered business method petitions. And so putting those filings in context, the AIA filings by month, which is slide number 4, there we can see that the filings were relatively flat during the first 6 months, and then there was a slow increase up until December of 2013. So that was about the first 18 months of the AIA proceedings. And then there was a dip. And I think what happened there was we had a bit of a wait and see time period where people who were waiting to file petitions, they wanted to see what those first final decisions looked like from the PTAB. And then in March of 2014 and on, you can see a big gain again in the rate at which these were filed. And I think myself and a lot of others attribute this to the fact that that people who were waiting to file, who were in that wait-and-see mode, saw that those petitions were being decided at a rate that was very favorable for petitioners, as we'll talk about in a little bit. And so it's pretty clear that a lot of potential filers liked what they saw. Maybe some people who were on the fence about whether or not to file an IPR or another proceeding, they pulled the trigger and got something on file. And then it looks like at the end we have a bit of a drop here in September of 2014. That's a little bit misleading. What I did was I just used the first 2 years, and because the filings opened in mid-September of 2012, I stopped them in mid-September of 2014. So if you extrapolate that and include the numbers through the end of September, then it would look more like we're at a flat period right now. So turning next to slide number 5, where we see AIA filings by technology area. As with a lot of litigation stats now, and to a lesser extent some prosecution stats, you have EE and computer technology areas that are dominating the market right now. Later, when we look at the filings by player, by petitioner, especially, you will see that a lot of telecommunications companies are really participating heavily in the AIA filings. This is consistent with what we see across the board with IP litigation, lots of cell phone wars and other wireless technology-related litigation and filings. And then also we have mechanical engineering at about 11%, chemical at a little over 7%, biopharma close to 6%. And so the next, turning to slide number 6, this shows the breakdown of the EE/computer science type technology areas. These are roughly broken down to the area of communications, 27%, semiconductors, 23%, software and operating systems, 18%, and then networks, 8%. And a lot of that is fuzzy. It's hard to draw those lines sometimes, but I wanted to give a general idea. And then the mechanical, chemical, and biopharma, those I didn't break down any further. So next, looking at slide number 7, looking at this I find very interesting, the PTAB versus district courts. And so as we talked about earlier, there have been about 2,000 total PTAB filings during the last 2 years. And during that same time, in all district courts across the U.S., there have been almost 12,000 patent cases filed. Now, if you look at the busiest districts, the top 3 are Eastern District of Texas, District of Delaware, and then Central District of California. The PTAB would be 3rd ahead of California and just behind Delaware if the PTAB was a district court. That's an interesting way to look at this because the district courts, obviously, people have been used to filing those for many, many years, and there's a lot of momentum there. There's a comfort level. But for the PTAB to get up from 0 to 60, so to speak, in just 2 years to be what would be the 3rd largest district or district court, it just shows how quickly people are flocking to this, to the PTAB, to this venue, to start their patent disputes. Now, one thing to keep in mind is that court cases can include multiple patents, whereas an IPR filing only includes 1 patent. So you may have 5 different IPRs that correlate to 1 district court filing if that 1 district court filing had 5 different patents listed in the complaint. So next, slide number 6, we look at institution here. So a lot of these stats have been widely distributed, but I want to skip down to recent trends. Since the PTAB inception, about 81% of petitions have at least 1 claim instituted, but in the last 3 months, that has dipped by about 8%. Now, remember that spike that we saw in the spring of 2014. That spike correlates with this dip that we've seen in the institution rates. And so one takeaway is, well, 2 possible takeaways. One is that more people who had what we could consider borderline invalidity claims pulled the trigger and filed because they saw the rates at which the PTAB had been invalidating claims. And also, people gained a comfort level and began to pull the trigger. And then another way to look at it is not that the PTAB responds to political waves or things like that, but Judge Rader's comments, which related to the rate at which the PTAB had been invalidating patents. And this spike, or this drop, slight drop in the rate at which petitions are instituted, it occurred a few months after Judge Rader's comments. I don't know that there's a correlation there, just pointing out the timeline. And then finally, we do see a difference in the institution rate for cases where the preliminary response is filed versus not filed. So Going to slide number 9, where we look at the final written decision. Again, these numbers have been widely distributed, so I don't want to spend too much time going over them, but 69% of the final written decisions have found that all instituted claims are unpatentable. One interesting thing here is that over the last 3 months, that number is unchanged. Now, in one respect, that's not surprising because that spike that we saw, the spike in filing, which correlated to the drop in institution rate, that is still about 6 to 9 months behind the final written decision. So if we're going to see an effect that correlates to those 2 events in the final written decisions, it won't be for another 6 to, well, about 9 months. And then, and also, I'd like to note that docketalarm.com provided a lot of these statistics. It's a new service that it's getting up and running, and not all the features are activated yet, but the ones that are, I found to be very interesting. So next, slide number 10, top players at the PTAB. This shows the busiest PTAB judges. As you can see, Joni Chang, Jameson Lee, and Sally Medley are the top 3 judges, and then after that there's a bit of a plateau. There's a lot of people who have 100+ petitions, but this top echelon of the 3 busiest PTAB judges, one explanation possibly is the fact that at the PTAB, we've heard several times that they'd like to staff cases with one experienced judge, at least one experienced judge, and then 2 additional judges. And so if you assume that Judges Chang, Lee, and Medley are the 3 of the most commonly staffed, what we could call more experienced judges, that explains why they have such heavy listed workloads, and hopefully in many of their cases, the 2 other panelists who have, in some cases, 50% or less fewer listed cases, hopefully they are doing a lot of the heavy lifting for the panel. And then finally, I wanted to show a quick look at the most common petitioners and the most common patent owners. It's not a shock here that the most common petitioners are practicing entities, and especially ones who are heavily involved in telecommunications and wireless technology, and that the most common patent owners in these IPRs tend to be non-practicing entities. And one quick question that I see now, I don't think we'll take all questions or answer all questions in real time. We might save some for the end, but I saw the question, are judges based on technical areas of expertise? Absolutely they are, and the PTAB tries, and in my experience, does a very good job of matching up judges' backgrounds with the petitioners in the patent owner's area of technology. And in fact, the judges are, in my experience, very technically sound and ask very good questions that show that they really understand the technology. So one final note before I pass the ball to Kelly Burris is the CLE code for this first section, and please feel free to write this down if you are applying for CLE credit, but that code is BRINKS, B-R-I-N-K-S, and the next 2 codes are not Gilson and Leon, so don't try and just skip the rest and assume that that's what we did. Okay, so with that, I will pass it to Kelly, and thank you very much, Kelly.
Hey, thanks, John. Nice job. Okay, so it looks like I have control. There's my contact information. If there's not enough time after the webinar today, if you have additional questions on amending claims, I'm happy to try to answer them. So we're going to talk in this next portion about amending claims during post-grant proceedings. And, you know, after reviewing the decisions and what's been happening to date, but probably should have titled this the inability to amend claims during post-grant proceedings, because there The patent owners have not met the PTAB with much success in their attempts to amend claims during these proceedings, and we'll talk about why that is, or why we think that is. However, there has been one case where the claims have been allowed to be amended. They were amended, although the facts of that case were somewhat limited. Both parties agreed to the amendments, and we'll talk about that in a later slide. But back to the basics of amending claims. Under the rules, under 37 CFR, and I would encourage everyone who's either new to the process or somewhat unfamiliar to make sure you read those rules, and then you read them again and again and again. The board doesn't seem to have much patience for either party not following the rules. So you have one opportunity to amend claims during these proceedings. The rules say that a patent owner may file one motion to amend a patent. There is an exception to that where if there's a good cause showing or a joint request of both parties to advance settlement, you could submit another motion to amend your claims, but there haven't been any of those so far, not that we're aware of. Before you submit your motion to amend the claims, you have to confer with the board. And that's basically a phone conference and discussing with the board and the other part and the petitioner, you know, what you'd like to do and the grounds for those claim amendments, which we'll talk about again here in a bit. And as far as timing goes, you can see on the slide here. Here's the timing for the entire proceedings. You have the petition gets filed. The patent owner has the option of filing a preliminary response, and then the PTAB makes their decision. And then there's a 3-month period where the patent owner prepares their response to the petition. And that's where you have to file your motion to amend the claims. And today what we're seeing is that PTAB has set a fairly high bar in order for the patent owners to amend their claims. As I mentioned, only one has been allowed to date. We'll talk about the page limits, the technical requirements, as well as the burden for demonstrating patentability over the prior art. In general, has made it very difficult for the patent owners to file successful motions to amend. I'd also like to point out here, I think part of the reason why we're not seeing a lot of success with these motions is because we're still a little bit early in the process. Both parties are kind of learning the ropes, and the rules are, being, decisions are coming out, and we're getting a little more and more guidance from the PTAB as we go. But I think you probably see a little more success down the road. And then I'll also mention, for those of you who are interested, the USPTO still has an open comment period right now on proceedings before the PTAB. That was supposed to end last week or maybe the week before, but they've extended that comment period to October 16th. And after reviewing all the comments that have been filed so far, you're seeing a lot of parties commenting on these motions to amend and how restrictive they are. So I think we can expect to see some changes down the road, at least in the form of more pages to file your motion. Okay, so let's move on then. There are some limitations on the ability to amend claims during these post-grant proceedings. First of all, you have to respond to a ground of unpatentability that's been raised by the petitioner. No broadening amendments are allowed, so very similar to the ex parte reexamination, the former inter parte reexamination proceedings. No broadening amendments, no new matter. And under the rules, you can only file a reasonable number of substitute claims. And what that has translated into with the decisions to date has been, of course, canceling claims, which the PTAB hasn't had a problem at all doing, or one substitute claim for each challenged claim. So that's quite a bit different and quite a bit more limiting than the former inter partes reexamination, where patent owners were allowed to present an unlimited number of amended or even new claims as a matter of right. Okay, so let's talk about the actual motion to amend itself. So in this motion to amend, I probably should have put that 15-page limit at the top. It's tough. It's really tough to get your claim amendments and the support for those amendments in this 15-page limit. And keep in mind that 15-page limit is 14-point font that's double-spaced as well. And in your motion to amend, it has to include a claim listing with the changes on the claims clearly shown in amendment format, and that claim listing is counted within your 15-page motion as well. And that seems to be in the comments that I mentioned earlier that are open right now. Almost every single comment I've seen on motions to amend have requested that that page limit either be increased or the claim listing be included as an appendix to the 15-page limit in the motion. In that motion, you have to provide support in your specification for the amendment, and as we'll see in one of the decided cases, if you're relying on an earlier filed priority application or a series of applications, you have to show support in each one of those priority applications as well. But more importantly, at least the real bulk of the work in your motion to amend is going to be demonstrating the patentability of your claims. In the idle-free systems case is the one that most people are referring to, the first one that really came out that articulated what a patent owner had to do in order to show a patentable distinction of their claims over the prior art. So as the moving party, the patent owner has the burden to show that they're entitled to those amended claims. They're not entered automatically, but only after they demonstrate by a preponderance of the evidence that they're patentable. So again, this is very different than re-examination proceedings or even patent prosecution. The board's called that out several times. They're like, look, we're not, you don't just send claims and we don't do a search and examine those claims. This is not an examination procedure. You have to prove to us that your claims are patentable, and then we substitute those claims right into the issued patent. So it's quite a different procedure. So in your motion, you have to identify specifically the feature or features that you've added to each substitute claim, and then you have to talk about that feature versus the prior art, not just the prior art of record, but prior art that's known to you as the patent owner. And you as the patent owner have to identify what the closest prior art is that's known to you. Not just a conclusory remark, but real reasoning as to what's the closest and why it's closest. Now you can start to see why this 15-page limit starts to become a bit of an issue. You have to discuss the level of ordinary skill in the art with respect to each added feature, and it's a lot of patent owners have commented to date that it's been very difficult to know what prior art to distinguish because there's so much of it, and you only have 15 pages to do that. There have been a couple of resource materials from the PTAB that have been helpful. One, I think it was Judge Bolick, posted on a blog back in May on how to make successful claim amendments, and he talked about making sure that you cover for each new claim element, discuss what was previously known, why it's not obvious. Don't limit your prior art to what the petitioner's prior art is. You have to make sure you're looking at the prior art of record and the prior art that you're aware of. And then there was a case, I think that's, I'm happy to send this out later too. The PTAB gave a hypothetical to clarify the burden for amending claims during IPR. It was the Avaya Network One case. And they basically said, look, if you have a new feature that you want to add to a claim, you have to establish the significance of that feature from the perspective of the level of ordinary skill in the art. And then you have to indicate whether that feature was known in any context, and if so, explain why it was known and why it's different and why it's important to your claimed invention, and then why one of ordinary skill in the art wouldn't have adapted that feature, et cetera, et cetera. So there was some pretty good guidance in that case as well. But again, you have to do all of that with this 15-page limit, and that has proven to be a bit challenging, to say the least. So some recent cases that I thought might be worth at least briefly mentioning. Again, the first case that was in which the PTAB allowed that motion to amend was the International Flavors case, and that was a chemical compound case, basically a compound for repelling insects. And it's important to note that the patent owner didn't file a patent owner response, but only filed a motion to amend. The petitioner didn't file an opposition to that motion to amend, so it was unopposed. And both parties confirmed that they didn't intend to file any further substantive papers. And what they did, what the patent owner did in that case, which happened to be the United States, they added additional Marcuse group limitations from a dependent claim into the independent claims. So, and they provided a lot of support for that. They submitted several publications as well as the declaration of an expert. And I think that that can't be underemphasized because that's not counted in your 15-page limit, by the way, to have support for what one of ordinary skill in the art would have concluded, or what they knew at the time and what they would have concluded. So that publication and the declaration of their expert was very helpful in that case. But again, a very straightforward claim amendment that both parties agreed to. So not really that earth-shattering. Quickly, the last couple of cases that I have here, the intervening priority applications. In that Toyota case, Toyota failed to identify through the string of applications the specific support for their proposed claim amendments, and so the PTAB kicked that one back at them. Yeah, so you have to go back and you have to identify that with specificity. You can't just say, well, it's in this application at this paragraph. It's in this application at that paragraph. You have to really, you know, pull out specific explicit support in your earlier application to show that that continuity through all your priority applications. And then the last case, Respironics, as we mentioned earlier, you have to provide support for the amendment in your written specification. In that case, the PTAB didn't conclude that the claim didn't lack support, but they concluded that the patent owner didn't come forward with sufficient evidence to demonstrate that they had the required support. They kind of got, the PTAB kind of beat up on them a little bit in this decision because they pretty much forced the PTAB to go through and find the support for themselves, and they said, we're not going to do that. That's your job. It's not our job. We're not going to grant this motion to amend. So let's move on. So they, and I think a lot of the decisions to date, you've seen the PTAB being pretty strict in following the rules and making sure that these trials stay on track for that 1-year period of time. So to date, we just have not seen the claim amendments that we thought we might see coming out of these proceedings. And so that concludes the portion of my slides. I'm going to pass the ball next to Rick DeMille, who will talk about discovery issues. And before I do that, the code for my portion of the webinar, which you can send with a check for $20 to Kelly Burris at kidding. So and it's not Gilson. So the CLE code for this second portion is September 30. So the word September 30, it can be one word or 2 words. So that's your code for this section. And Rick, the ball is yours. Thank you, everyone.
Thank you, Kelly. For my portion, I'm going to talk about discovery in post-grant proceedings, specifically the 2 common types of discovery we see, routine discovery and additional discovery. The link I have here on this slide, slide 18, is to a blog, an AIA blog that actually posted just today explaining routine discovery and additional discovery. So after this, if you want any more information, they also have a lot of examples of cases where this type of discovery has been at issue. There's one other type of discovery that I won't be addressing. It's called mandatory initial disclosures. It's not used very often, though I would stay tuned to the AIA blog. The blog that posted today indicated that there'll be an upcoming entry discussing mandatory initial disclosures if you want more information about that. So first, discussing routine discovery. this is what you might call self-executing discovery. This is not something that either party has to ask for. These are the routine discovery defines certain papers or evidence that the parties are under an obligation to produce. These include any exhibit cited in a paper or testimony, such as an expert declaration, any paper that the expert relies upon should be served to the other side, and it should be served with the citing paper or testimony unless it was previously served with a prior filing. Routine discovery also includes relevant information that is inconsistent with the position advanced by that party during the proceeding, and it should be served with the filing of the document containing that potential inconsistency. Though this does not include privileged documents, you're not under an obligation to produce any documents protected under work product or attorney-client privilege. This routine discovery includes information that may be known to inventors, corporate officers, or persons involved in the preparation of the filing of the documents. Routine discovery also includes cross-examination of affidavit testimony. A party that is going to rely on an affidavit of an expert should make that expert available for cross-examination during the IPR proceeding. And as mentioned, this discovery is self-executing, which means you do not have to ask the board for authorization to request this information. Both parties should be providing it. Now, additional discovery. Additional discovery is limited compared to what type of discovery would be available and typically available in district court litigation. The rationale for this is that given the short time deadlines under which the PTAB operates, the PTAB is not going to allow the proceedings to become bogged down in discovery. Before I get into the substance of additional discovery, I just want to go over briefly the procedure for requesting additional discovery. Before you raise anything with the board, you should confer with your opposing party about your discovery request and try to come to some sort of agreement between you. If you can come to an agreement, then you don't even have to involve the board. You just produce what you agreed to produce. If there is no agreement or there's some dispute, then you would initiate a conference call with the PTAB to request authorization to file a motion for additional discovery. In that conference call, the PTAB is going to ask you the relevance and why you need this. They'll really go through some of the factors that I'm going to talk about later, trying to drill down and probe whether authorization should be granted. If authorization to file the motion for additional discovery is granted by the board, then that moving party would file a motion for additional discovery, and in that motion they would need to explain or show that that additional discovery is in the interests of justice, which is the standard for IPRs. For post-grant, the standard is a showing of good cause. So as I mentioned, these are the two standards. I'm on slide 21 for additional discovery, interest of justice for inter-parties review, a showing of good cause for post-grant review, which includes covered business method patent review. Now, even though the standard for additional discovery is a little bit lower for post-grant review as compared to inter-parties review, the board goes through the same 5 factors in determining whether to authorize additional discovery. And these are commonly referred to as the 5 Garmin factors. In the next slide, I have a cite to the Garmin case, which is what the board always cites to as outlining the standard for granting additional discovery. So I'm going to go through each of those 5 Garmin factors. The first factor is that there must be more than a possibility and a mere allegation. What this means is that the party requesting additional discovery, this is how the board has explained it, that the party requesting additional discovery should be in possession of some threshold amount of evidence or reasoning tending to show beyond speculation that something useful will be uncovered. What they mean by useful in this context is that useful doesn't just mean that information is relevant or even admissible. Useful means that it's favorable in substantive value to a contention of the party moving for discovery. And so the first factor basically means the board's not going to allow you to go fishing or submit speculative requests for discovery. You need to have some basis for knowing that what you're asking for is not just relevant, but that you kind of have to know already what you're going to get. The second factor is litigation positions and underlying basis is not allowed to be the subject of additional discovery. So asking for the other party's litigation positions and their underlying basis for those positions, the board has found is not necessary in the interest of justice. The third factor is the ability to generate equivalent information by other means, or in other words, if the requesting party could reasonably collect or compile the information on their own without a discovery request, the board is not going to grant that request. They would find that that's not in the interest of justice. Moving on to the next slide. The fourth factor, the fourth of the Garmin factors, is that the instructions must be easily understandable. This is an example that I quote here is from the Garmin case. The board said, for example, 10 pages of complex instructions for answering questions is prima facie unclear. The final of the 5 Garmin factors is that the request cannot be overly burdensome to answer. That's just given the expedited nature of these proceedings, any requests need to be easy to respond to and not create an undue burden. The types of burdens that the board looks at are financial burdens, burdens on human resources, burdens if responding to the request would create a burden on meeting the time schedule of this proceedings, then the board is likely not to grant the request for additional discovery. In this next slide, I just wanted to highlight a recent decision that relates to a request for additional discovery. This decision issued September 15th, so just a couple weeks ago. In this instant, the patent owner sought authorization to file a motion for additional discovery related to commercial success. They were seeking certain information about commercial success. The board denied that request for additional discovery. The board said that the patent owner had failed to explain the nexus between the claims and the alleged commercial success. So this relates to, let me jump back to the Garmin factors. This relates to the first Garmin factor, where you need to have some kind of initial or threshold showing of evidence or reasoning as to the relevance of what you're looking for. And so in this instance, the board wanted the patent owner to explain, show that there's some nexus between what they're looking for and the claims before they allow them to ask to obtain this additional discovery. Let me just read the quote from the board here that's instructive. They said, patent owner does not point to any specific language in the method claims or otherwise explain how patent owner might be able to show a nexus between the features of those claims and any commercial success. So I want to highlight a few practice tips for requesting additional discovery. This first bullet point relates to things that the moving party should keep in mind. Before they contact the board seeking authorization to obtain additional discovery, they need to possess some kind of evidence or reasoning to show that what their request is more than just speculative. They need to. The board wants to know that, basically see that the moving party knows what they're asking for, and they need to be demonstrated with specificity and some kind of basis for the request. They need to demonstrate the relevance. They need to be able to just demonstrate and explain the relevance of that further evidence and how it will advance or contribute to a position or issue that's at issue in the proceeding. I cite here a case, a Microsoft case, and I'm going to go through some of the factors that the board looked at there. In this Microsoft case, the moving party sought additional discovery related to secondary considerations. That request was not granted. And there's some examples under the second bullet point of some of the requests that were made. And I just wanted to highlight these as kind of being illustrative of how reasons the board will not grant a petition, and these should be kept in mind. So, for example, the requests made by the moving party were not time limited. They were open-ended as far as what time period the requests applied to. One of the requests were for any upgrades by customers. This request related to information about a software program. Another request was for sales figures for unspecified programs that included this RDC application or equivalents. Again, the board felt that that was broad, too broad and not specific. Another request was for information on any Microsoft product that are offered with or without this RDC, as well as documents concerning benefits and value of the RDC application or documents that illustrate the demand for the RDC. These were all factors the board identified as not being too broad, not narrowly tailored to what the moving party really was looking for. The board found that these, as I mentioned, that these requests were insufficiently focused, that they were overly broad, and because they were overly broad, it would have been unduly burdensome to respond to these requests. Now, I've cited here at this last bullet point a partially successful motion for additional discovery. The three items under this bullet point are the three types of additional discovery that were asked for. The board granted on the first, but not on the second two. And on the next slide, I will go through each of those and explain the board's reasoning. So the board did grant additional discovery for laboratory notebooks and other documents containing protocols followed in creating and testing compositions and the underlying data for the test results. Jumping back to the first of the Garmin factors, this requirement that there's some threshold showing of evidence or reasoning. What the moving party pointed to in this instance were statements made by the non-moving party's experts during their deposition referring to the lab notebooks as being relevant. And so the moving party pointed to that testimony of the other side's experts in reference to the lab notebook, saying, you know, they've talked about this as being a factor in their opinion. We need to see these lab notebooks, and you know, by referencing them, we know, you know, it's more than just a speculative request. You know, it's a specific request for those notebooks. The board granted that request. Now, there were two other requests that the moving party made that were not granted. The first one was for samples of the compositions as prepared by Corning, which was the petitioner, the non-moving party. The moving party was not specific about which samples were needed. It just requested samples of every composition. The moving party did not show that the request would not be unduly burden the petitioner, and they did not adequately explain why it could not gather that information on its own or through cross-examination of the other side's experts. And so the board denied on that request. The board denied on this last request for any testing results that are inconsistent with the petitioner's position and the alleged prior art composition inherently possesses the claimed property values and associated privilege log. The board found that the moving party did not sufficiently explain why it needed this information. It provided no indication that it was in possession of any evidence showing beyond speculation that something useful would be uncovered by this request. And it did not explain why the request would not be overly burdensome. And so just to sum it up, for a moving party to request authorization to file a motion for additional discovery, the moving party really needs to take off the litigation glasses. And litigation, our discovery requests are often broad and intentionally so. That's just not going to work in the patent office. They want a specific request. They want you to explain why it's relevant. You know, what issue is it relevant to in the proceeding? and you need to have some already existing basis to show to the board that when you get that information you're asking for, it's going to have some useful information. And as I mentioned, useful doesn't mean relevant or admissible. Useful means that it will advance some contention made by the party in that proceeding. On the flip side, if you are the non-moving party and you're opposing a motion for additional discovery or a request for additional discovery, the strategy is fairly simple. You just go through each of the Garmin factors and you just, hammer on each of those, point out that they didn't provide the threshold showing of evidence or reasoning, that something useful will be provided, that the request is not specific, and you point to maybe the open-ended portions of the request and say that it would be burdensome to respond to these open-ended requests. And you just go through each of the Garmin factors and point out where the moving party's request does not satisfy those. Okay, that concludes my portion of the presentation on discovery. Before we move on to questions that anyone may have, the final code for this CLE is post-grant patent, if you want to write that down. That's 3 words, so no hyphens, post-grant patent. And now we will answer any questions that anyone may have.
So, and this is John. One question that I saw on here that I'd be happy to answer is, to what do you attribute the drop in petition institution rate over the last 3 months? I touched on that earlier, but I'm happy to go back briefly. I think that a lot of people were waiting until until final decisions started coming out so that they could see what the PTAB was doing and what the metrics were, and also some anecdotal information as well as statistical information. And at that point in time, a lot of people jumped on board and started filing, even if they had more borderline claims. And that's one possible reason that institution rates have gone down. Also, it's possible that the PTAB is possibly slightly swayed by the overwhelming statistical evidence, and things were kind of normalizing. I don't know that that's the case. It's just something that could happen, and certainly I hope that the PTAB is evaluating every case on its merits and on its face, and not responding to numbers or questions about those numbers themselves. Kelly and Rick, do you have any questions that are listed here that you'd like to answer?
Yeah. Yeah, go ahead. There's a question on mandatory disclosure there.
Yes. So the question is, if I'm aware of if we're aware of any examples of someone provided relevant information that they admitted was inconsistent with a position advanced by that party. I am not. That's not something that you see very often, or I haven't seen that where that type of routine discovery was provided. I have seen cases where, as part of where one of the parties asked the board to compel the other party to produce something that they thought was inconsistent with some position they took, and the board has consistently responded to those, as far as I could tell, responded to those requests as finding that that's not routine discovery, and that the board needs, that party needs to initiate that request as a motion for, or as a request for additional discovery, and then they go through the Garmin factors. So the short answer is I'm not aware of any examples. That's not something that you see that people produce as part of routine discovery are things that are inconsistent with some position that they've advanced.
This is John again. I see another question that is, do you foresee the rate of filings continue to rise? You know, I think that the filings will, at the very least, I think they will plateau and maintain their current level. And if I could go back to, or Rick, since you have control, actually, if you could please go back to the monthly filings slide. That's slide number 4. That'll give us some reference. Thank you. So what I think will happen at the very least is that we will see filings remain constant right around that 160 petitions per month number, which we've seen the monthly filings around there for the last 5 to 6 months. But I also think that it's very likely that petitions start to steadily but slowly rise again. I think that what we see in the final decision numbers is that the final decisions are, the PTAB still at a very high rate is invalidating claims. And even when some petitions are not instituted, as long as the PTAB continues to invalidate the instituted claims at a high rate, I think we will still see a high number of filings. I don't know that we'll see dramatic shifts like we have seen in the first 2 years. I think things will change at much smaller increments and slower paces going forward. So in other words, I think things will stabilize or have stabilized. But I do think that people all over different industries and areas of technology are realizing what a powerful tool the PTAB is for challenging patents. It's able to be done at a much less expensive cost and a shorter amount of time when compared to district courts. And it's even though in most cases the estoppel provisions are very strong, it is a very good alternative to district court litigation. And for that reason, I think that cases will continue, or filing rates will continue to rise.
Yeah, and then in kind of tacking on to that comment, John, I see a question here about where the PTAB judges are located. Right now, the majority of the judges are still located in Alexandria, although here in Detroit, there are, I think, 8 or 9 judges now, and they've recently built out hearing rooms upstairs. So as the judges become more senior, they're going to start having PTAB hearings here in the Detroit office as well. And they're trying to recruit more currently. And then in the other 3 satellite offices in Denver, Dallas, and San Jose, I believe those have been staffed with judges as well. I don't know the exact count, but in those offices you have just judges right now and not yet any examiners, whereas upstairs here in Detroit we've got 85 examiners and the 8 or 9 judges. But I would anticipate that those numbers would be increasing. And then it looks like there's a question here on what is the duty of disclosure in an IPR? Well, John, if you want, I'm not really clear what specifically that duty refers to.
This is John Kelly. Sorry to cut in, but I think I know what it's getting at. If it's asking about something parallel to initial disclosures in a district court litigation, then yes, there are the mandatory disclosure requirements that Rick talked about. As he mentioned, there is not, that provision is not often seen, or we don't see it invoked very often, partially because I think people understand they have a duty to disclose any inconsistent positions that they take in their petition, so they don't take those positions. But then there's another point in time during the proceeding when I think it also comes into play and is perhaps it actually does come into play much more often than the mandatory disclosure requirements, and that's where there's an amendment to claims. When you make an amendment to claims as the patent owner, you have to disclose any prior art that is relevant, and you have to point to it and describe why it's most relevant, and you also have to have your expert witness basically submit a declaration indicating that the expert is not aware of any additional prior art that's more relevant, and show why your amended claims are patentable over all of that cited art, because it is the backdrop for amendments. As Kelly talked about, the patent owner has the obligation to show patentability. It's really flipping the tables.
Yeah, this is Rick. Let me, and just to build upon that, I just want to give one example where, you know, this requirement to provide inconsistent information may come into play, just maybe to help illustrate. One I was thinking of is if, for example, a patent owner is relying on surprising or unexpected results to rebut an allegation of obviousness. So the patent owner, in producing their surprising and unexpected results, would also need to submit any evidence, non-privileged evidence, that would be inconsistent with those unexpected properties. So that may be an issue I can think of where, you know, you have these unexpected results, but there were some anomalous other readings that weren't consistent with that. You should provide all of it, and you can, you know, explain in your filings, you know, that why one is more probative than the other. But that may be an example where you would want to provide some information that's inconsistent with the position that you're taking. I could take this. There's another question. For IPRs, how have judges treated the filing of multiple petitions challenging the same patent on alternative grounds? Are the judges just granting proceedings on the petition with the best grounds, or on all the petitions independently? The board, it's the former for the most part that I've seen. If you file multiple petitions on the same patent or on the same claims of a patent addressing multiple grounds, the board is often looking at that as if it's all just one petition. And so I have seen petitions denied on the ground that the grounds raised in that petition are redundant over grounds raised in another petition. So there are instances where, you know, the board has instituted an IPR on multiple grounds or a post-grant or a CBM. But often they're just picking the best argument, and if you submit multiple petitions, they're going to look at all of them as a whole, and it's not a I can't say that they do that 100% of the time, but that's consistently that's the approach they seem to be taking.
And this is John. I agree with Rick, and also to one quick note, the PTAB does a good job of consolidating related petitions. If you file petitions on patents that are in a same family, or even in the case where it's multiple petitions on the same patent, you're likely to get the same panel across the board, and the hearings will either be consolidated formally or de facto consolidated, where things you say in one can be used in the other. And it looks like we are up against the end of our allotted time here. But thank you, everyone, for the great questions and for attending and participation. And we look forward to doing more webinars like this in the future. Thanks for making the first one such a great one.
Thanks, everyone.
Ladies and gentlemen, that now concludes today's webinar. You may disconnect your lines.